Hi, I'm Candice Malcolm, and this is the Candice Malcolm Show. We have an excellent episode for you today. Wow, a lot going on in the world of Canadian news. We're going to talk about Bill C-2, which is Mark Carney's new attempt to spy on all Canadians. We're going to talk about Attorney General Sean Fraser and how he completely contradicted himself and he caved to radicals just one day apart. Finally, we're going to talk about a parent and a school council member and what happened to her after she refused to do a land acknowledgement in Hamilton. Folks, please like this video. I'm going to ask you just to quickly hit that like button. It really helps us with the YouTube algorithm. We want to be discovered by as many Canadians as possible. So my guest today, I'm very pleased to be joined by John Carpay. John Carpay is a constitutional lawyer and he's president of the Justice Center for Constitutional Freedoms. And he's the author of a new book, Corrupted by Fear, which explores how Canadian courts failed to properly scrutinize government overreach during COVID. And we are going to talk about that as well. So John, welcome to the show. Thank you so much for joining us.
Glad to be with you.
Well, first, I want to talk about this Liberal border bill and how it threatens Canadians and our privacy. So this is all, of course, in response to what has been happening with the border, with fentanyl, with the Americans. It's always under the guise of a big, important security event. But people are really starting to raise the alarm. This is a 140-page bill. So it seems to me that the government just wanted to throw in all kinds of other things into this bill. So I'm going to read a little bit from University of Ottawa law professor Michael Geist, because he wrote a long blog post on this that I think is really important. He writes, this is his blog post called Privacy at Risk, Government Buries Lawful Access Provisions in New Border Bill. He writes, the government yesterday introduced the Strong Border Act, Bill C-2, legislation that was promoted as establishing a new border measure provision, presumably designed to address U.S. concerns regarding the border. Yet buried at the bottom of the bill are lawful access provisions that have nothing to do with the border. The provisions raise the prospect of warrantless access to information about internet subscribers, among other things. He writes, much like the government's overreach last year from the online harms bill, Bill C-2 overreaches by including measures on internet subscriber data that have nothing to do with the border, but raise serious concerns about civil liberties. So I'm wondering, John, what is your takeaway? What do you think about this bill as being introduced?
It's terrifying. There are provisions to restrict the use of cash. There are provisions that will allow police for the first time to intercept mail, which repudiates a 157-year-old Canadian tradition of privacy that dates all the way back to Confederation in 1867. Canada Post gets new powers to open mail, and then we have this without a warrant access. And, just as background, warrants are a crime-fighting tool. And so the starting point is we all have a privacy right. But if the police have reasonable and probable grounds to believe that, let's say, Mark Smith, just invented name, is got fentanyl or child pornography in his home, they have reasonable tips, reasonable leads, they can go to court and somebody needs to swear an affidavit on which they can be cross-examined in the future. And they need to apply to a judge to get a search warrant. And so they could violate the privacy rights of Mark Smith because they have reasonable and probable grounds to do so. They could intercept his emails, read his emails. They could get a search warrant to go into his home. And so they can show up suddenly and just walk into his home and it's legal. But the search warrant is so important as a protection of the 99.99% of Canadians who are law-abiding. The police does not, in the name of crime fighting, have the right to enter your home. And so what we have with the Strong Borders Act is included in the 140 pages, there's a provision whereby law enforcement authorities can demand of anybody providing electronic services, which is pretty broad. That might include your organization and my organization. I mean, if we're sending out emails about constitutional rights and freedoms, that could be an electronic service. We have to, on demand, produce and turn over our email lists, and provisions in there as well would require releasing the locations of where people live or where their IP address is. So it's all crime fighting. It's got to be, we have to be protected by legal requirement for law enforcement to get a search warrant. This is being this is being repudiated. So it's extremely dangerous.
Well, okay, so we have Ottawa yesterday, Public Safety Minister Gary Annansangari, and he claimed that the bill is in line with the Charter of Rights and Freedoms and that it strikes the right balance between expanding powers and protecting the individual. Let's play that clip.
In order for me to bring forward legislation, it needed to have the safeguards in place. It needed to be charter in line with the values of the Canadian Charter of Rights and Freedoms. And I fundamentally believe that we have strike the balance that while expanding powers in certain instances does have the safeguards and the protections in place to protect individual freedoms and rights.
I think a lot of Canadians really want to take action when it comes to fighting illegal immigration and crime specifically, as well as fentanyl. So Canadians, there is an appetite for this. But what do you make of the minister's claim there that it strikes the right balance?
Politicians and other government officials never take away our rights and freedoms without offering a nice sounding pretext. And so the pretext here has got some nice sounding things. Most Canadians legitimately, myself included, we want strong borders. We don't want to have non-existent borders where anybody can just walk into Canada or fly into Canada and just stay here without lawful authorization to do so. But whenever politicians bring legislation that violates rights and freedoms, they always say, oh yeah, we've looked at the charter. This complies with the charter. We've taken charter values into account. There are safeguards here to protect privacy, to protect freedom of expression. The safeguards are there. They said that with the Online Harms Act that they brought in about a year and a half ago, or a year and several months ago. They always say that it's charter compliant because that's it's kind of a political speaking point. But what we're learning about the bill so far, and it's a bit of a slow process, being 140 pages, is terrifying. And no, it doesn't comply with the charter.
Well, there you go. I want to take note because I don't usually agree with the establishment journalists, but this time even they have expressed concern. So here we have Althea Raj of the Toronto Star. Her headline says, "Border Bill primed to give Mark Carney's government sweeping new powers, but who asked for it?" On X, she criticized it. Next, we have Robin Urbach from the Globe and Mail. She writes, "So it appears the Carney government decided to pair a bunch of mostly reasonable reforms to our asylum claim system with a bunch of insane crap that expands law enforcement surveillance power because we needed that question mark." And finally, Chris Selly in the National Post writes, his headline says, "Liberals wrap much needed refugee reform in a terrible privacy invading packages." He writes on X, seems kind of Trumpy, right? So I know you probably share my view that for the most part, the legacy media is not to be trusted. But when you even have legacy media people like Althea Raj and Robin Urbach saying this isn't what anyone asked for and we shouldn't be doing this, do you think that the Liberals will listen and maybe try to break this bill in half at least and take out some of the things that people are raising concerns about?
Well, there's a good chance of that. It depends on pushback as well for Canadians, especially those who are living in an electoral district where their member of parliament is a Liberal. If those MPs get a lot of pushback from their own constituents, that's going to bear influence. Another mainstream media person, Marie Wolf, wrote in the Globe and Mail yesterday, raised these same flags that this is allowing law enforcement to access all kinds of information about people's names, email addresses, location of IP server without a warrant. And I'm thankful that this seems to be across the board, that there is a real concern for privacy. I mean, be nice if others were also, strong champions of the freedoms of expression, religion, conscience, association, peaceful assembly, and they're not. But here, at least when it comes to privacy rights, we seem to have people from across the political spectrum that are raising alarms.
Well, I'm old enough to remember back in 2015, John, when Stephen Harper introduced an anti-terror bill, right? This was 2015. The backdrop was we had Islamist ISIS fanaticals in Canada. One of them shot and killed an unarmed soldier standing ceremoniously on guard. I'm talking about Nathan Cirilla. Then that madman broke into Parliament, fired shots very close to politicians like Stephen Harper and Justin Trudeau. And so in response, the terror bill that he implemented received huge pushback from the establishment people, from the powers that be. I'm going to show this joint letter that was signed by dozens, hundreds of organizations and law professors across the country. So this is from the Electronic Frontier Foundation. They signed a joint letter urging Canada to dismiss the anti-terror legislation. And folks, you can just see, look at the names of the organizations that signed this. Like there's I don't know, a couple dozen, plus all of these very fancy law professors and other university professors, probably 100 of them. And so they were very up in arms. I think, by today's standards, that bill seems quite mild compared to some of the things that the Justin Trudeau government has had introduced. And now here we are with Mark Carney introducing things that just have nothing to do with each other. So I know it's early days, right? This was just introduced. Maybe the Canadian Civil Liberties Association and other groups are drafting letters as we speak. But I'm wondering, do you expect to see this level of pushback against the Carney government?
Well, based on what we've seen so far about the bill's contents, I would certainly hope so. The other frightening thing is that this kind of legislation works hand in glove with a new Online Harms Act. If the federal government reintroduces the same bill or similar legislation, so on the one hand, law enforcement gets easy access without a warrant to private and confidential information of thousands or even millions of people. And then at the same time, if you have something like an Online Harms Act that is going to put a chill on speech, that's going to allow the federal government to pass regulations where they get to define what is hateful. And those two together, it's absolutely terrifying, and the technology is there. We know how social credit works in China with, if you criticize the government on social media, next thing you know, you can't go shopping, you can't get onto a train or a plane or a subway or a bus. The technology is there to facilitate worse tyranny than what we've ever experienced before.
And it seems like that's the way that they're heading. Okay, I want to switch gears a little bit, John, and ask you about Canada's Justice Minister, Attorney General Sean Fraser. He seems to have either flip-flopped or sort of capitulated to the radicals here. So this is all in the backdrop of that First Minister's meeting that happened in Saskatoon earlier in the week. The idea that Mark Carney is really focused on creating energy corridors, making Canada an energy superpower, and yes, the prospect of new pipelines. So Justice Minister Sean Fraser, this is on Wednesday, he was asked about this and specifically made this comment saying that Indigenous communities don't have a blanket veto power over natural resource projects. Let's play that clip.
There's the potential to have a more direct impact on Aboriginal and treaty rights. It demands a higher degree of engagement. The commentary has suggested to date that it's not necessarily a blanket veto power, but of course we're in new territory here.
And so looking a little frazzled there, but on Thursday, Sean Fraser came back and he actually apologized for those comments, saying that he shouldn't have said them and that instead he should have just rejected the premise of the question. Let's play that clip.
Despite innocent intentions, I think my comments actually caused hurt and potentially eroded a very precarious trust that has been built up over many years to respect the rights of Indigenous people in this country. And it's essential that we work in partnership with Indigenous partners when it comes to issues that engage their rights and demand the respect of the Crown. What I should have done when faced with the question that I received was rejecting the premise of the question.
So it seems like he got a talking to, John. I don't know if it was from the Prime Minister's office. News outlets have reported that the AFN chief gave him a call, probably gave the Prime Minister's office a call as well. And you could see that he was sort of groveling for, just saying that he shouldn't have said it and that wasn't what he meant. And so I'm wondering, what do you make of this sort of, I don't know to call it a flip-flop or capitulation, and the broader question of getting pipelines and national projects to fruition without having small interest groups being able to hijack the process?
Well, it's encouraging to hear the Prime Minister say that, we do need these pipelines. Alberta right now is, and therefore Canada as well, we are losing huge sums of money by being forced to sell our oil at a discounted price to the United States because we don't have full access to tidewater, so we can't sell the oil to other countries. It's a self-inflicted wound, and so we are losing massive revenues by selling to the Americans at a lower price because they're the only ones we can sell to, because we've shot ourselves in the foot and not built these pipelines. Now, it's good to hear support for the pipelines, but there's this qualification where Prime Minister Carney says that's subject to Aboriginal veto for whatever they deem to be their traditional lands or unceded lands, which is pretty vague. And then environmental concerns, which are legitimate. But when he says environment, he's talking about his theory that mankind controls the climate. And then a third one is that any development has to be subject to the public interest as defined by the government. So on the one hand, it's like, yeah, we're for pipelines, but Aboriginals have a veto. We believe that mankind controls the climate. So if the pipelines are going to interfere with that control of the climate, it's not going ahead. And if the government thinks it's not really in the national interest. So really, you don't have serious support for pipelines. And I think the Attorney General, Sean Fraser, I think his first comments were far more reasonable than the subsequent backtracking in response to hurt feelings.
Well, especially when we have a situation where you can have hereditary chiefs, like not even elected people in these communities, but people who have deemed themselves through their bloodline the arbiters of whether Canada gets to have an economy that works or not. And the idea of what the Trudeau government has given, pardon me, has paid homage to before, the idea that First Nations do have veto power and that we adhere to United Nations protocol that requires, what is it, prior informed consent, whatever that means, which is a gray area. They are given outsized power in our society. I want to tie this to another story, John, which is really quite something. I know you at the Justice Center are focused on this case. So a parent in Hamilton, basically she calmly expressed her opposition to land acknowledgements. You know, the land acknowledgements. We saw King Charles do one, embarrassingly, before his throne speech, basically saying that Canada is not a legitimate country and that it's unceded land, it's not our land. Well, she expressed calm opposition to it. And we're going to talk a little bit about what happened to her. And we're going to talk about John's book on COVID government overreach. But folks, we're going to cut off the YouTube stream right here because whenever I talk about these topics, my videos get demonetized. YouTube doesn't like us talking about these comments. So we're going to switch it over to junonews.com. Come join us over there for the rest of the conversation. And we can be a lot more open about our real thoughts and beliefs because we're not facing any kind of government or YouTube censorship. So head on over and watch the rest there.